completing the uploading of information into the database on all the perpetrators, suspects, and criminals. And over the next couple of months, we will be contemplating how to enable the prosecutors in the region to be able to use the database on an equal footing with the Croatian prosecutors. So that's all I have to say for now. Thank you.
Thank you very much for your explanations. Before passing the floor to our attendants, colleague Vukcevic, in 2-3 minutes, please, how do you assess cooperation today? We know that in addition to the normal problems all colleagues have, there are, of course, important expectations in relation to the remaining fugitives. So how do you deal with all this pressure?
Good morning to all. Let me start with that question then. That question is a very delicate one. It is hard for me to give an answer. My only answer can be that we are doing everything we can, if I understood your question correctly, to bring this to an end. For the time being, all the necessary prerequisites have been met, those that were not there during the previous government. Namely, a clear political will has been shown to bring this job to an end.
Thank you very much. What are the main challenges you have as war crimes prosecutor? Our colleagues, prosecutor generals from the other countries, are having, in addition to the important war crimes cases, many other issues to deal with in relation to organized crime, corruption. You have a specialized office in relation to war crimes. Are your resources today sufficient to deal with the remaining cases?
May I respond now? I believe that prosecutors' offices in Serbia do have resources to respond to all these challenges, namely war crimes and organized crime. However, since I'm the war crimes prosecutor, I would like to restrict my remarks to that. It is hard for me to add anything new after everything we've heard from my colleagues. The situation is as it is in the region. My colleague, Mr. Bajic, gave a comprehensive sketch of what the situation is, what the problem is, and the way of finding a way out of this situation. I fully support what he said. I'm glad that he remembered to say that the Brioni process is a continuation of the Palic process, but that is where we started our cooperation. And indeed, we have an outstandingly good communication. That, after all, was the first agreement that we signed, all three of us, although Mr. Barashanin was not a signatory, then it was Mr. Jurcevic. But anyway, what is important is our will to cooperate. So it had to do with pre-trial proceedings. We prosecutors know the best how delicate and sensitive that is, and how invaluable information received in that part of the proceedings is. Afterwards, what was reached was a more substantive agreement. We had legal and constitutional obstacles, like not being able to extradite our own citizens, and also not to refer cases that are over 10 years old. And since we are talking about war crimes, we basically had a total ban on referral. But we managed to bring to justice, nevertheless, quite a few perpetrators, and we surmounted the obstacles in that way. So we saw that there should be no obstacles for bringing criminals to justice. Once again, I would like to speak of cooperation with the ICTY, or rather with the Office of the Prosecutor. From the very outset, our cooperation was good. Our mutual confidence increased as time went by. I agree with my colleague, the chief prosecutor, that indeed prosecutors are independent as well. It's not only court, because a court that is, or courts that are independent. If we're talking about the policy of the prosecution of crimes, and if the prosecutor is not independent, what are we talking about? There are so many who have an important role to play. NGOs, for instance. But we know, both Mr. Bajic and I, how important it is for us to carry out professional prosecutions. I'm not speaking in Mr. Barashinin's name because we haven't had that much cooperation yet, but I also need to add that there is something I noticed in the previous panels, terminology that is used, like calling judiciaries local judiciaries, and that bothers me. And then training of judges and prosecutors, training, education, etc. I'm bothered by this because these are states that have legal orders of their own. I don't need to be trained. It's soldiers and sportsmen who need training. I don't need training. So that is what bothers me. However, what I would like to point out is how I see the role of the international community. In 1993, the United Nations established the Tribunal, and that was the most important thing that was done when they showed these military and political elites that started the war machines going, and they created all of this horror, when they showed them that they would ultimately be brought before justice and held responsible for what they did. That is what I wish to point out.
Thank you very much, colleague Vukcevic. Time is really running out. I think it's time that we pass. Briefly, please. Yes.
Allow me, in addition to some good things that I attributed to the Hague Tribunal, to mention that there is a burden that has yet to be solved by the ICTY while it still exists, and it should be done together with the international community. So in addition to the legacy of the ICTY, and in addition to the evidence, the good practices and the established standards, there is a burden that exists in the region and Bosnia and Herzegovina in particular. Let me remind you that at the time when the Rome Statute was adopted, these rules and provisions prevented domestic systems to prosecute anyone. There were arrests happening everywhere, and the Rome Treaty and rules stopped this kind of practice. And only after the ICTY had reviewed all the evidence, then the domestic organs were allowed to arrest potential perpetrators. I would like to tell you that there is chaos slowly setting in Bosnia and Herzegovina. There is restriction of movement of people. We have parallel judiciary. We have that both our office of the prosecutor and offices of the prosecutor in neighboring countries are conducting parallel investigations. For that reason, people are afraid of traveling and being arrested at airports or anywhere else. For that reason, I think that we have to introduce rules and make all the regional countries, particularly in the area of exchanging evidence and referring the cases, meaning that only one single prosecution office in the region can conduct certain investigations and prosecution, and not that people feel this kind of uncertainty, not knowing where and when they can be arrested. I appeal to the representatives of the international community and the ICTY officials to raise this issue and not to close down until this burning issue of the region has been resolved.
I will start. Who has not yet spoken? No, the right side, the gentleman. On your right, yes, please.
Dobar dan, Tim Gazivoda iz Centra.
Teams Gazivoda from the Center for Human Rights, Zagreb. Good morning. A bit more than 10 years ago, one of Mr. Horvatin's predecessors said that he was a president of the Supreme Court, that war crimes cannot be committed in self-defense. Over the past 10 years, the Croatian judiciary asserted that that could be the case, unfortunately. Everything that we heard from Mr. Horvatin and Mr. Bajic indicates that very important progress made by the Croatian judiciary in that direction, namely having impartial proceedings take place, including this segment of war crimes proceedings. Nevertheless, there still are problems involved. They talked about that, and reports indicate these problems. The Center for Peace from Osijek and many other NGOs have stated that in their reports. However, I wish to speak about a specific problem that we discussed informally yesterday. Mrs. Nataša Kandić raised it as well. That is the danger of document abuse. That is to say, archives, materials that will be transferred from the Hague Tribunal to the judiciaries of Croatia and other countries. Judge Robinson spoke about the importance of having the consent of the persons involved before personal information is divulged. Then there is the question of the importance of national security documents and so on. So there is the legal domain. On the one hand, the prosecutors are a kind of liaison. They have certain insight, at least up to a degree, into information of this kind. And then, on the other hand, there are judges who will have insight into such information in the future, more and more so. The important thing is that this information ultimately, how is it going to spill over, as it were, into the media even from the legal domain? Thank you.
Thank you. I take, with the micro, take a question from Mother of Srebrenica, and then
Ja vas pozdravljam sve.
I would like to greet all of you, and I'm going to put 4 questions to the Chief Prosecutor from Serbia.